Free my daddy, and I'll make you walk. The words were spoken by a child's voice in courtroom 4 on a Thursday at 11:20 in the morning, and within a day they were being repeated by news feeds across the country. But for the first 3 seconds after them, the courtroom held a perfect silence, and then the courtroom laughed. Not everyone laughed, and not cruelly, indulgently, into fists, the way people laugh at a child who has said something foolish at a grown-up gathering. The press row, a couple of jurors, someone in the gallery. Prosecutor Davis lowered his head, hiding a smile in his papers. 3 people did not laugh. The defendant, a tall, worn-down man at the defense table, who closed his eyes as if struck. A silver-haired man in an expensive coat in the last row, who on the contrary leaned slowly forward. And the judge, Judge Robert Caldwell, never laughed. Everyone in that courtroom knew it. Now let's rewind 10 minutes. It was the third and final day of State versus Nathan Reed. Reed, a surgeon, was on trial for involuntary manslaughter. 8 months earlier, a patient had died on his operating table, and the prosecution maintained that the doctor had violated protocol. Closing arguments had been delivered. The jury was about to retire. Judge Caldwell was already reaching for the gavel, when the heavy courtroom door was shoved open by 2 small hands. A girl of about 10, red pigtails, a jacket too light for the weather, a cardboard folder pressed to her chest, made it halfway down the center aisle before the bailiff managed to step into her path. "I need to tell the judge one thing," she announced to the whole room. "One. Then you can take me out." "Abby!" The defendant shot to his feet so fast the chain on his wrist clanged against the table. "Abby, no. Your Honor, this is my daughter. I don't know how she shouldn't be here." "Sit down, Mr. Reed." Judge Robert Caldwell was 56, and for the past 3 years he had entered this courtroom by a special ramp to the left of the bench. A crash on a mountain road, 3 surgeries, 11 surgeons in 4 countries, and one shared word from all of them: inoperable. Lawyers called him granite behind his back. In 11 years, he had never reversed a single one of his own rulings, and after the accident, he had only grown harder. In Granite's courtroom, nobody wept, nobody shouted from the gallery, and certainly nobody burst in mid-session, which was why the entire room was startled when he said, "Approach." The girl walked the remaining distance. You could see now that her knees were trembling, and that her chin was lifted at exactly the angle needed to hide it, and stopped before the bench, tiny under the 4-meter seal of the state. "What is your name?" "Abigail Reed." "Abby, you're trying my dad for something he didn't do." "That is for the jury to decide, young lady. You have one thing. I'm listening." And then she said her sentence, and the courtroom laughed its laugh, and Judge Caldwell raised one hand, without raising his voice. He never needed to, and the laughter died. "Young lady." Granite looked down at her with the long look of a man whom, over 3 years, everyone up to, and including the governor, had learned to pity, and who hated that more than the chair itself. "My spine has been examined by the best surgeons of 4 countries. They all said the same thing. Do you understand what you are saying?" "Yes, sir. I understand it better than anyone in this room." Abby opened her cardboard folder and took out a sheet of paper. 11 surgeons saw your scans, I know, and the 12th one, who saw them too, is sitting at that table over there in handcuffs. A year ago, your clinic sent your scans out for an anonymous consultation. You might not even know. They don't put names on those. Patient RC, 55, compression injury. Dad studied them 4 evenings in a row. And then he told Mom at dinner. I heard it. I always hear when people whisper, "Everyone gave up on this man for nothing. I know how to put him back on his feet." A movement went through the room. No longer laughter. "This is a copy of his notes on patient RC." Abby rose on tiptoe and laid the sheet on the edge of the bench. "I took them from Dad's study. That's probably not allowed. But a few months after these notes, they arrested him, and I decided, better not allowed than never." She stepped back and finished, looking the judge straight in the eye. "Patient RC is you, Your Honor. I checked the date of your accident. It all matches. My dad is the only person on earth who said possible about you when 11 people said impossible. And you're about to send him to prison for a mistake he didn't make. He doesn't make mistakes at all. He even operated on my turtle when the vet said to put her to sleep. A turtle, sir. She's still alive. Her name is Judge. Abby faltered for a second. Sorry, it just happened. She couldn't walk at first either. In courtroom 4, it became so quiet you could hear the hum of the ceiling lights. Judge Robert Caldwell stared at the sheet of paper on the edge of his bench. From where he sat, he could see the heading, the unfamiliar handwriting, and a diagram of a spine he knew by heart. His own. He was silent for 7 seconds. The court reporter later swore she counted. Court is in recess until 9 o'clock tomorrow morning. The gavel came down once. The judge took the sheet from the bench. Bailiff, the girl is not to be removed. Show Miss Reed to my chambers, with whoever is responsible for her. And, Miss Reed. Granite leaned forward, and for the first time in 3 years, that courtroom saw something on his face that was not a verdict. The name of the veterinarian who was wrong about your turtle. I want to know who else in this town says impossible ahead of schedule. And in the last row, the silver-haired man in the expensive coat rose without a sound and was the first out of the room, already dialing as he walked. In the judge's chambers, Abby Reed looked even smaller than she had in the courtroom. She sat on the edge of a leather armchair, swinging legs that didn't reach the floor, studying the shelves of bound case law. Beside her sat her mother, Sarah Reed, a thin woman with eyes red from lost sleep, in the nurse's scrubs she hadn't had time to change. They had pulled her off her shift with a phone call from the courthouse, and for the first 5 minutes she apologized without stopping, until Caldwell raised his palm. Mrs. Reed, your daughter interrupted a session, breached order, and apparently removed documents from your home that she should not have removed. He held the pause. It was the most useful breach of order my courtroom has seen in 11 years. Compose yourself and help me understand what is going on. Let's start simply. Why is a child handling her father's case alone? Sarah Reed clenched her hands in her lap. Because I gave up, Your Honor. She said it straight out, and Caldwell noted where the daughter got the manner. 8 months ago, we had a house, Nathan's practice, and a lawyer who kept saying, it's obvious the doctor is innocent. Now we have a rented apartment, my double shifts, and a public defender with 40 cases. I held on for 7 months. In the 8th, I started teaching my children to live without their father. And Abby? She looked at her daughter. Abby decided that if the grown-ups had given up, it must be the children's turn. Nobody asked whose turn it was, Abby put in. I just took it. Hush, sweetheart. Let her talk, said Caldwell. Miss Reed, your father's notes I will read tonight myself, first page to last. But the notes are about my spine. He is on trial for something else. Tell me about that operation. What you know. Not from the newspapers. From home. Abby stopped swinging her legs. Dad didn't sleep for 4 nights after. At all. I heard him walking around the kitchen saying the same thing to Mom over and over. I did everything by protocol. The machine showed normal. He should not have died. She raised her eyes. Dad never said, I'm not guilty, sir. He said, he should not have died. That's different. He wasn't defending himself. He couldn't understand. Caldwell leaned back slowly in his chair. 11 years on the bench teach you to hear phrasing. The guilty say, I'm not guilty, from the first interview like an incantation. People who truly did everything right say it exactly the way Reed had said it. This should not have happened. They aren't defending themselves. They are working a problem that will not resolve. What happened next? Next, the hospital got very fast, Sarah Reed said quietly. A review board in 3 days. Conclusion, violation of anesthesia protocol, responsibility of the operating surgeon. Nathan was terminated before the week was out. His machine data from that operation, what was handed to investigators wasn't the original logs but a printout, certified by the hospital. Nathan asked for the raw files from the machine itself. He was told the retention period had lapsed and the data had been overwritten. 3 weeks after the patient's death, Your Honor, against a mandated 5-year retention. The chambers went quiet. Caldwell studied the woman in nurse's scrubs very carefully. Was this raised at trial? The defender filed a motion. Denied. Loss of data does not establish its contents. Sarah smiled wearily. Mercy General has a legal department of 9, Your Honor. We have Gary, who has 40 cases and good intentions. Caldwell turned his gaze to the window. He had not presided over this case from the beginning. It had been transferred to him after the recusal of the first judge, routine rotation. He had taken the trial at a stage when all motions had already been argued. He had judged by what was in the file. What was in the file was a certified printout. Mrs. Reed, last question, and it matters. Who was the patient? Thomas Wakefield, 61. A scheduled heart operation. Sarah paused. The hospital's Board of Trustees, Your Honor. He was the chairman of the Board of Trustees of Mercy General. He came naturally to his own hospital, to its best surgeon. That evening, Judge Caldwell sat at home, in a study with the overhead light off, reading Surgeon Reed's notes on patient RC. He read them for 3 hours. He had no medical training, but he had 11 years of practice at telling thought from the imitation of thought, and 3 years in which he had learned enough about his own spine to sit an exam on it. The 11 opinions in his desk drawer he knew nearly by heart. All of them were written the same way, from impossibility. Risks were listed, contraindications were listed, and the conclusion grew out of them on its own. Cannot be done. Reed's notes were written in reverse, from the goal. Objective, restore conduction. First obstacle, workaround. Second obstacle, workaround. 12 pages, and on every one of them, this man was not explaining why it couldn't be done. He was working out exactly how it could, honestly flagging the margins. Risk high, requires assistance at the Ferris level. Window, 4 hours, no more. The last line was underlined twice. I estimate probability of success at 60 to 65%. Probability if nothing is done, 0. I do not understand my colleagues. Caldwell set the pages down and sat motionless for a long time. 65%. For 3 years he had been offered 0, a polite, unanimous, international 0. The man who had written, I do not understand my colleagues, was sitting tonight in a holding cell, awaiting a verdict that was to be delivered by him, Judge Caldwell. Tomorrow at 9. He rolled to the window. Below lay the city, somewhere in it, the Mercy General Hospital with its 9 lawyers, its overwritten logs, and its late chairman of trustees. And somewhere a rented apartment where a red-haired girl was asleep, hugging, quite possibly, a turtle named Judge. A judge named Judge, thought Caldwell. Life has a taste for rhymes. He picked up the phone and dialed a number he had known by heart for 3 years. Martha, it's Caldwell. Wake me tomorrow at 6. Yes, I know I don't sleep. It's a figure of speech. I need Grover here by 7. Tell him there is a question in the Reed case on which I apparently have no right to remain the judge. And there is a second question on which I have no right not to remain one. Have him come and help me put those 2 questions in separate rooms. And, Martha, pull everything public on Thomas Wakefield, especially who took over the Mercy General Board of Trustees after his death. He hung up and looked at the 12 pages on the desk. And at that same hour, on the other side of the city, in a restaurant closed to customers 2 hours earlier, the silver-haired man in the expensive coat, Edward Voss, chief counsel of Mercy General Hospital, was saying to the man across the table, the judge took the girl's papers off the bench. Personally, I saw his face, Douglas. I've been reading his faces for 11 years. That was not curiosity. If he starts pulling, Voss turned his glass. Everything comes out. The logs, the machine, and the reason the machine is still standing in operating room 3. The man across the table dabbed his lips carefully with a napkin. Then arrange it so the judge has no tomorrow, he said, and seeing Voss's face, winced. Procedurally, Edward. No procedural tomorrow. God, the people I work with. A recusal. Find me grounds to recuse Judge Caldwell by 9 a.m. Grover arrived at 6:40, 20 minutes early, with coffee, with a briefcase, and with the face of a man whom judges do not wake at 6 in the morning over trifles. Malcolm Grover had spent 30 years on the appellate bench, retired, and had since performed a single function for which half the judges of the state kept him in excellent whiskey. He was the man a judge could ask a question without fearing the question would become a record. Caldwell laid it all out for him in 15 minutes. The girl, the notes, patient RC, the logs, Wakefield. Grover listened, staring into his coffee, and as the account went on, his face grew more and more pleased, which signified the highest degree of alarm. "So, 2 rooms," he said at last. "Room 1, you cannot pass verdict on a man who may be the only person on the planet capable of putting you on your feet. A personal interest in acquittal, pure as a tear. Any not guilty from your lips will smell all the way to the appeal. You are obligated to recuse yourself, and you know it. I know it. Go on." "Room 2. Grover raised a finger. "Self-recusal is a renunciation of the verdict. It is not a renunciation of conscience, and it is not an instantaneous loss of authority. Until the case is reassigned, you are the sitting presiding judge with full powers. And if a sitting judge has become aware of the possible destruction of evidence in his own trial," he sipped his coffee, "then a sitting judge has roughly 2 hours in which to be very much sitting." Caldwell was already writing. He signed the evidence preservation order at 7:31. The anesthesia machine from operating room 3 of Mercy General, to be seized and sealed, the servers holding the primary logs, to be mirrored under supervision, the machine's maintenance journals for 3 years, to be produced in the originals. Grounds: information regarding possible loss of data, raised at trial and previously denied without examination. At 8 sharp, 2 court officers and a technical expert entered the service entrance of Mercy General. At 8:21, the senior officer called Caldwell personally, and there was something strange in his voice. "Your Honor, reporting? The machine from operating room 3, we seized it, off a forklift. It was being wheeled out as we arrived. The waybill says, 'Scheduled disposal of obsolete equipment,' dated this morning, 6:45. The disposal company's truck was at the loading dock. Half an hour later, Your Honor, and it's the crusher. Document all of it. The waybill, the truck, the name on the signature." Caldwell paused. "Who signed the disposal order?" "Directive of the legal department. Signature, E. Voss." Caldwell hung up and looked at Grover. Grover finished his coffee and said with feeling, "30 years in appellate, and I have never seen timing like this. They panicked. Robert, panic is a beautiful thing. Panicking people leave signatures." At 9 sharp, courtroom 4 was fuller than it had been even on the trial's opening day. The girl's sentence from yesterday was already living in the news. At 9:01, an unfamiliar lawyer walked in. Expensive suit, leather portfolio, train delivery, and requested the floor before the session began. A motion to recuse the presiding judge. Grounds: the information publicly stated in this courtroom that the defendant had consulted on the judge's injury created an irremediable conflict of interest. "The motion is filed on behalf of whom?" Caldwell inquired. "We represent the interests of the aggrieved party, the Wakefield family, and of Mercy General Hospital as an interested person." "Interested," Caldwell repeated. "Good word. Enter it in the record. We will be needing it." He lifted a sheet from the bench. "Your motion is 59 minutes late, Counselor. At 8 o'clock this morning, I submitted to the Chief Judge my own declaration of recusal, with a full statement of circumstances, including several you are not aware of. The case will be reassigned to Judge Feldman. But since, until the moment of reassignment, the presiding judge is still me, let us place on the record my 3 final orders in this proceeding." The room went still. "First, at 8 this morning, on my order, the anesthesia machine from operating room 3 of Mercy General, the machine whose readings this prosecution is built on, was seized and sealed." "Seized," Caldwell paused, "off a forklift, in the act of being hauled to disposal, scheduled last night and papered this morning at 6:45. A coincidence on which the specialist may comment. Second, the materials concerning that coincidence, and equally the loss of the primary logs 3 weeks after the patient's death against a 5-year retention requirement, are being referred by me to the State Attorney's Office for review on indicia of obstruction of justice. Third, the defense motion to compel the primary data, previously denied, is to be heard anew by Judge Feldman in light of what has been seized." He looked at the expensive lawyer over his glasses. Your motion to recuse is granted, counselor. Late, but granted. Tell your clients, Judge Caldwell no longer presides over this case. Judge Caldwell is now merely a very attentive resident of this county. Court is adjourned. The gavel came down once, and the room detonated. Press, flashes, roar. Nathan Reed sat at the defense table with his face in his hands. In the third row, Sarah Reed gripped her daughter's hand, and Abby, half risen, was looking not at her father, at the judge, rolling down the ramp and out of the hall. At the very door, Caldwell slowed the chair, turned his head, and found her eyes. He did not smile. Granite didn't know how in public. He inclined his head briefly, almost invisibly, as to an equal. That evening, Grover came again, without coffee this time, with a thin folder. Martha dug it up. You asked. The Mercy Board of Trustees, after Wakefield's death, was taken over by Douglas Mercer, owner of Mercer Medical Group. 8 months in the chairman's seat. Now watch the hands, Robert. Grover laid out a sheet. 3 years ago, Mercer Medical sold Mercy a batch of anesthesia machines, that very model. And a year and a half ago, the manufacturer circulated a quiet recall bulletin on that model. A defect in the delivery sensor. In rare cases, readings may diverge from actual concentration. Do you know what a recall replacement across the entire Mercer network costs? Martha ran it roughly. It starts with a 9, and the word after the 9 is not million. Wakefield was chairman of the trustees, and judging by the minutes, the only one who last year kept raising the question of an unscheduled equipment audit. Caldwell looked at the sheet for a long time. So the man who demanded the machines be inspected died on a table connected to such a machine, and a surgeon answers for it. And the surgeon, Grover nodded, is the one man who can raise you out of that chair. 30 years in the law, Robert, and I'll tell you as a specialist, fate has an appalling sense of humor and an impeccable sense of composition. The examination of the machine took 9 days, and for all 9 days the city followed the case like a championship final. Judge Feldman, a dry woman of 60 with a reputation as someone in whose courtroom neither tears nor connections worked, by her first order returned the denied defense motion for rehearing, by her second appointed an independent technical examination with representatives of both parties admitted, and by her third changed Nathan Reed's custody status. Bail and an ankle monitor, but home. Nathan Reed walked out of county jail on a Tuesday at 11 in the morning with a cardboard box in his hands, and for the first seconds stood on the steps squinting like a man emerging from a dark room. 8 months had been exactly that. Then 2 figures came running across the parking lot, a woman in nurse's scrubs and a red-haired girl shouting something as she ran. The box hit the asphalt. The press shot that embrace from every angle. One frame. Abby latched onto her father, eyes squeezed shut and mouth open in a howl that was finally a child's, finally not a courtroom's. Became the state's front-page photo by evening. The caption in the largest paper read, "The Girl Who Didn't Give Up." And on Wednesday, the experts came to inspect the sealed machine. And with them, by separate order of the court, a consultant for the defense, Dr. Nathan Reed, with a monitor on his ankle, admitted for the first time in 8 months to the machine that had broken his life. The examining engineer later told colleagues that in 20 years he had never seen a man inspect equipment like that. Reed circled the machine the way one circles an operating table, silently, twice, and then asked them to open the delivery sensor block and looked inside with one long look. "There," he said, and stepped back to let the documentation cameras in. The serial number of the block. Check it against the manufacturer's recall bulletin. The defective range will be in your expert's files. And the maintenance journal. This block was supposed to be replaced under recall a year and a half ago. Look at what the journal says. They checked. The number fell inside the defective range. In the maintenance journal, opposite the recall date, stood, "Replacement performed, unit updated," signed by the service contractor. The block in the machine was the original factory unit. It had never been touched. The replacement had been performed on paper. "Now look here," Reed spoke quietly and evenly, in the voice of a man who had waited 8 months to say this in front of witnesses. "The sensor defect in this batch is a divergence between displayed and actual concentration during long operations. Cumulative. The machine shows normal. The anesthesiologist sees normal. The surgeon hears normal from the anesthesiologist. And the patient, meanwhile, is receiving something other than normal. During my operation, the machine showed perfect numbers right up to cardiac arrest. That's in the very printout they drowned me with. The prosecution said, the instruments were in order, therefore the man erred. The instruments were indeed in order. In exactly the order someone left them in, with a paper replacement and a genuine defect. The engineer took off his glasses and wiped them, the gesture with which technical people replace profanity. Dr. Reed, if the cumulative divergence is confirmed, this isn't only your patient. How many long operations went through this machine in the year and a half after the replacement? By the operating log, about 200, said Reed. I counted them my first night after the arrest. I have had a great many nights, engineer. I counted everything. The examination report landed on Judge Feldman's desk 9 days later. A defective block, a fictitious replacement record, a divergence reproduced on the test bench. By the 4th hour of operation, the machine lied by a margin the expert's report described dryly as clinically significant. Prosecutor Davis, reading his copy in his office, got to that line, set the report down, and sat motionless for a long while. Then he called in his deputy. Draft the motion. We are withdrawing the charges against Reed. He rubbed his eyes. And get me the state attorney's office, their mercy task force. I have a present for them, the person who certified that printout 8 months ago, and the person who signed the replacement record. Let them ask both who requested the signatures. The asking did not take long. The service contractor and a small 3-technician shop broke on the second interview. They had been told to draw up the replacement record, backdated for the paperwork. The call had come from the hospital's legal department. The payment had gone through with a surcharge for urgency. The technician spelled the caller's name letter by letter. Edward Voss learned of it from his attorney on Friday evening, and on Saturday morning did what lawyers of his training do when they see the ship hold below the waterline. He walked into the state attorney's office himself, with counsel and an offer of cooperation. I need 1% of what you want to know, he told the investigator. The other 99 I will give you free in exchange for a deal. I'll start with the essentials so you grasp the scale. The disposal of the machine, the fictitious replacement, the pressure on the review board. That was me. I admit it. I will put it in writing. But the decision not to replace the blocks under recall across the entire Mercer Medical Network, not just at Mercy, was not mine. A year and a half ago, there was a meeting, a narrow one. I was instructed to prepare a legal risk memo for it. I wrote in it, verbatim, in the event of an incident with a fatal outcome, the recommended strategy is localization of liability at the level of medical personnel. Voss raised his eyes from the table, translating from the legal. If somebody dies, designate a doctor as the guilty party. The memo was addressed to Douglas Mercer. It has been preserved. I preserve everything, you understand. I am a lawyer, not a romantic. The investigator was silent for about 5 seconds. You realize your memo is a blueprint of what happened to Dr. Reed, written a year before his operation? I realize it, Voss said evenly, which is why I am here and not on a plane. When the plan in a memo executes itself, letter for letter, a lawyer must choose which side's witness he intends to be. I have chosen. And speaking of letters, he clicked open his briefcase. Wakefield, the late chairman, 1 month before his scheduled operation, requested from me a list of equipment subject to recalls. I stalled the answer. Mercer's instruction. He never received the list. He went on to that table not knowing the machine at his head came from the defective batch. Voss laid a thin folder on the desk. I am not asserting this was planned, investigator. I am asserting it was permitted. Legally, the difference is enormous. Humanly, judge for yourselves. That is your line of work. The charges against Nathan Reed were formally dismissed on a Monday at 10 in the morning. Judge Feldman read the ruling in 4 minutes, and those 4 minutes were carried live by 3 channels. And at 10:40 that same morning, in front of the press, staked out at the Mercer Medical Group Tower, Douglas Mercer was walked out of his own office. The state attorney charged him, at the first stage, with what was ironclad: obstruction of justice, falsification of records, fraud in medical equipment. The question sounding in every broadcast, whether he knew, sending Wakefield to the table without the recall list. The prosecution was keeping to itself for now. Voss's formula, permitted or planned, was already living in headlines, and the country argued over the difference. Mercy General announced a review of all 200 operations performed on the defective machine. The Board of Trustees resigned in full. Nathan Reed received calls from 3 clinics with offers, and from the State Medical Board, with apologies and notice of the reinstatement of his license on a priority basis. All of this Abby Reed learned from the television, sitting on the floor of the rented apartment and providing commentary to the Turtle. The Turtle received the news with restraint, and on Tuesday evening the doorbell rang, and on the landing stood a court officer, the one from courtroom 4. Only now he was off duty, embarrassed, and holding an envelope. "Miss Reed, a letter for you. Hand delivery. I was asked to do it." He hesitated. "With dignity. So I came in uniform. We don't have anything more dignified." Inside the envelope, on heavy paper, in a judge's hand, was written, "Miss Reed, in our line of work it is not customary for a judge to thank participants in a proceeding. Kindly regard this letter, therefore, not as gratitude but as a summons. You are hereby summoned on Thursday at 4 o'clock in the afternoon to 14 Willow Lane for tea. Attendance is mandatory. Parents are admitted. The Turtle-named judge is admitted first of all. We judges have few colleagues we trust. R.C." Judge Caldwell's house turned out to be single-story. Abby understood why the moment she saw the ramps. And tea in it was served on a veranda overlooking a garden overgrown exactly as much as a garden overgrows when its owner has not been able to reach it for 3 years. For the first half hour, the adults spoke carefully, the way people walk on thin ice. About the case, almost nothing. About the weather, far too much. Abby ran out of patience first. She set down her cup and said, "You didn't want us here for tea. You wanted to ask Dad about the operation. Yours. You've wanted to for a week and you're afraid to. I can tell. Mom looks the same way when she doesn't want to talk about money." "Abby," said Sarah and Nathan in chorus. "Out of the mouths of babes," said Caldwell. "Stand down, parents. In this house, Miss Reed holds the floor for life." He turned the chair toward Nathan, and everything hospitable left his face. What remained was direct. "She's right, Doctor. I am indeed afraid to ask. For 2 reasons, and I'll name both honestly. First, you owe me nothing. It wasn't I who freed you. The facts freed you. I merely kept them from being burned. If there is 1 gram of gratitude or debt in your yes, I don't want that yes. One doesn't operate with it. And second," he smiled without any mirth, 11 people said, "Impossible." I spent 3 years learning to live with their impossible, and I had nearly succeeded. Your 12 pages broke all my training. The frightening thing is not hearing no, Doctor. The frightening thing is hearing yes again and losing it again. The veranda went quiet. Nathan Reed looked into his cup for a long time. "Then let me be honest too, Your Honor, about my 2 reasons to be afraid." He raised his eyes. "First, I have not held a scalpel in 8 months. Surgery is not memory, it's hands. Before I say yes to you, I have to say it to myself. And for that, I need a month in an operating room on scheduled, simple, other people's cases. To test not my knowledge, my hands. The second reason," he paused, "I assessed your case at 60 to 65%. That was a year ago, from the scans. A year without surgery with your progression narrows the window. I need fresh imaging, and then I will give you a new number, and it will be lower, and you will decide by that number and not by hope. And I need an assistant. In the notes I wrote, at the Ferris level. That's not a level, it's a surname. Catherine Ferris. We trained together. The best second pair of hands I have ever seen. She's in Houston now. Whether she'll agree to stand at a table with a surgeon who 8 months ago was a defendant in a patient's death, I don't know. She'll agree, came from the end of the table. Everyone turned. Abby was finishing her third cookie with the air of a person in command of the situation. I wrote to her. Back on Friday, I found her hospital online. They have an Ask a Doctor form. I asked. She licked a finger. I wrote, "Hello, my dad is Nathan Reed. You've probably seen the news. He is going to need an assistant at the Ferris level soon, and that's you. Please don't book anything for the fall." She answered yesterday. 2 words and a question mark. When and where? Abby surveyed the speechless adults and shrugged. Well, what? You two would have spent another month being afraid to ask each other. Grown-ups waste a terrible amount of time on that, and the judge has a spine. Waiting is bad for it. Caldwell looked at the girl for several seconds. Then he turned to Nathan. Dr. Reed, who conducts the negotiations in your family? I have now established. Your terms are accepted, all of them. A month for the hands, fresh imaging, an honest number, Ferris. 1 counter condition. He held the pause. When this is over, however it ends, you will replant this garden for me, both of you, with Miss Reed in a supervisory role. For 3 years I have watched it die, and I am tired of looking at things I cannot walk to. I intend to walk to it. Is that clear? Clear, said Nathan Reed. Clear, said Abby. Can the turtle be let out in the garden? She can weed. Well, almost. The fresh imaging was done in the first week, and the new number turned out to be 45. Nathan Reed delivered it to the judge himself, looking him in the eye, with no cushioning preamble. As promised. 45% probability of success. The year of waiting had eaten 15 to 20 points. The compression had advanced, and the window in which entry still made sense would, by his estimate, close within 6 to 8 months. After that, a zero no longer polite but final. 45, Caldwell repeated. Less than half. Less than half, Reed confirmed. I promised you a number with no hope mixed in. This is it. The decision is yours and I won't rush you, but I'll stall you even less. Caldwell was silent a long while. Then he said, For 11 years I have decided other people's lives by a majority of one, myself. It would be comical to falter before a decision about my own. He turned the chair toward the window, beyond which the garden was dying. We play, Doctor. 45 is 45 more than anyone has offered me in 3 years. What followed was a month scheduled to the day. Nathan Reed returned to an operating room on the 4th day after his license was reinstated. Not at Mercy, which was courting him with apologies and a promotion. He chose the county hospital, plain and honest, where the chief of surgery told him in front of everyone, The hands remember, Doctor, but we'll be checking you like an intern. No offense. Reed took none. He had asked to be checked like an intern. The first week, assisting on other surgeons' cases. The second, simple scheduled procedures under supervision. By the end of the third, the chief looked at his suturing and said only, Well, what did I tell you? The hands remember, and signed an unrestricted clearance. Catherine Ferris flew in 10 days before the date. She turned out to be small, quick, with a voice built for carrying over operating room noise, and from day one adopted the habit of calling the judge our patient, as though all other patients in the world had been temporarily suspended. She and Reed ran the operative plan 11 times, on models, on the imaging, minute by minute. The 4-hour window from the old notes had shrunk over the year to 3 hours 40 minutes, and every one of the plan's 220 steps had a number, an owner, and a fallback. You haven't changed, Ferris said after the 6th run, still preparing as if luck had been abolished by hospital order. Luck is what's left over when the preparation is finished, Reed answered. You can't lean on it. You're only allowed to be glad of it. Abby participated in the preparation in the only role available to her. She declared herself responsible for the patient up to the door and took the office seriously. In the final week, she came with her mother to the judge's house every other day, delivered turtle bulletins, beat him at checkers. I won't let you win. You said it yourself. Court must be honest. and once leaving, got stuck in the veranda doorway. Judge Caldwell, are you scared? Judges aren't issued fear, said Granite, and after a pause added, I'm scared, Miss Reed, for the first time in 3 years. For 3 years I wasn't scared because I didn't care. So this fear I will wear with a certain pleasure. It means I have something to lose again. Dad's scared too. He thinks I can't tell, but I can. He's walking around the kitchen at night again. Only before, he used to tell Mom he should not have died. Now he tells her he has to walk. Abby considered and added with expertise, that's different. That's the good kind. The operation was set for a Tuesday at 7 in the morning. At 6:30 in pre-op, Caldwell, Martin, already on the gurney, stopped the orderly with a gesture and beckoned Reed over. He spoke quietly so that only the surgeon heard. Doctor, whatever happens in there over the next 4 hours, remember what I'm about to say, word for word. I have a professional relationship with phrasing. You have already fulfilled your daughter's promise. She said, I'll make you walk. For 3 years, I was a dead man who moved on wheels. This past month, I have been a living one. A living man who, for the moment, sits. The distance between those two states is greater than the distance between sitting and walking. Take it from a man who knows all four. So go in and work calmly. The main case is already won. What's left is the appeal. Noted, Your Honor, said Nathan Reed. See you in 4 hours. We'll discuss the garden. I remain in favor of apple trees, and you keep digging in. Maples, doctor. That is not open to argument. Everyone's more agreeable under anesthesia, said Reed, and Granite, for the first time in anyone's memory, laughed out loud, and was still laughing when the doors of the operating room closed. The operation ran 3 hours and 31 minutes. In the corridor, on the hard chairs, sat 3 people. Sarah, Abby, and Grover, who had arrived unannounced, said, I'm here on a legal matter. Sat down and never once opened his briefcase. Abby held a terrarium on her knees. The turtle had not been admitted past the lobby, but Abby had cited the judge's letter in which the colleague is admitted first of all, and the hospital security staff, who read the newspapers, surrendered. Every 20 minutes, a nurse came out and said, proceeding according to plan, and each time Abby nodded as though receiving a report. At the 211th minute, it was not a nurse who came out. It was Catherine Ferris. In her cap, mask lines pressed into her face, and the face was exhausted and very calm. Well, responsible for the patient, she said, finding Abby with her eyes. Reporting. Conduction restored. Response in the lower extremities present. On the table, objective, documented. What follows is months of rehabilitation, and nobody will tell you today whether he'll run marathons. But your dad is standing over a microscope right now, finishing the kind of work I have seen twice in my life, and both times it was him doing it. She crouched down in front of the terrarium. And you, colleague, have my personal thanks for the phrase, don't book anything for the fall. I've had it framed. I show it to interns as a model of informed consent. Abby Reed looked at her, then at her mother, then at the terrarium, and burst into tears, out loud in gulps like a child, the way she had not cried in the courtroom or outside the jail or once in all those 8 months because somebody had had to hold the line. And now it was allowed. The turtle received the news with restraint. Judge Robert Caldwell stood on his own legs 4 months and 11 days after the operation. In March, at the Rehabilitation Center, between 2 parallel bars, under the supervision of 2 physical therapists and 1 turtle. The turtle had been brought in by special dispensation. Abby had insisted that the colleague must be present at the setting of precedent, and Caldwell had sustained the motion. The first steps looked the way all first steps on earth look. Short, hard, knuckles white on the bars, 4 steps out, arrest, 3 back. The physical therapists applauded with restraint. Abby wept and filmed simultaneously. The turtle, positioned at the finish point as motivation, studied the linoleum. For the record, said Caldwell, lowering himself into the chair and catching his breath. 7 steps. I consider this session held. Abby's video, 30 seconds. A trembling camera. The operator's off-screen howling. he permitted her to post. By evening, it stood first in the state's news under a headline nobody had to invent, because the whole country remembered the sentence from the courtroom. She made him walk. By May, Caldwell was walking with a cane. By summer, he was furious that it was with a cane. Ferris, flying in for a follow-up, pronounced, "Our patient has returned to his baseline state of granite. I consider rehabilitation complete." The trial of Douglas Mercer ran all winter, and the country watched it the way it had once watched the Reed case. Only now the right man was sitting in the right chair. Mercer held to his line to the end. Tragic managerial negligence. Didn't know, didn't go into detail, trusted the reports. The line was broken twice. First by Voss, laying out by date the memo on localization of liability at the level of medical personnel, and the instruction not to answer Wakefield's request for the recall list. The second time, by a quiet staff auditor who found in the Mercer Medical Archives an internal memorandum 3 years old, with a calculation, the cost of replacing the defective blocks across the network versus the estimated cost of settling potential incidents. The settling came out cheaper. Beneath the calculation stood Mercer's initials and a note, "Agreed. We proceed under the second scenario." Potential incidents means people, the state prosecutor said in closing, raising the memorandum over his head. The second scenario is Thomas Wakefield. It is Dr. Reed who spent 8 months in a jail cell according to someone else's plan. It is 200 operations that families are now re-examining. The defendant did not kill with his own hands. The defense is right about that. He did something worse. He signed a price list on which a death cost less than a repair. The jury deliberated 9 hours. Guilty on all counts. 22 years. The review of the 200 operations yielded what people had feared and hoped for. In 170 cases, the machine had not had time to lie critically. The operations were short. In 30, unexplained complications were found that now had an explanation. The families received acknowledgement, compensation, and, many said this mattered more, the internal reprimands lifted from their doctors. Mercy General, under a new board of trustees, made its first act the creation of an independent equipment ombudsman engineer. The post, at the new board's insistence, was named the Wakefield Chair. Nathan Reed declined the offers of 3 metropolitan clinics and stayed at the county hospital. The chief of surgery, the one who had checked him like an intern, named his successor without hesitation on his way to retirement. The Reeds moved out of the rented apartment in the spring. The house they bought was small but had a yard. The yard was Abby's condition. Her colleague had been cooped up in a terrarium long enough, and Judge Caldwell returned to courtroom 4 in September, a year after that Thursday. The ramp to the left of the bench was dismantled at his own request. The first thing he did on walking into his courtroom was issue a directive the bailiff would afterward recite to every new hire. "The aisle that a certain young lady came down last year is to be kept clear at all times. In this courtroom, it must remain physically possible to reach the judge, just in case." They planted the garden in October, on a weekend, with the whole strange company this case had assembled. The Reeds in full strength, Grover with saplings. "I'm here on a legal matter," he said, unloading shovels. Ferris, who had flown in to assess the patient's motor function under field conditions. And Martha, who commanded everyone. The apple versus maple dispute was resolved the way things were resolved in this company by now, through the intervention of a third party. Abby heard out both positions, declared arguments closed, and handed down her ruling. Half the garden, the judge's maples, half Dad's apple trees, and on the boundary, 1 cherry tree. Because the cherry belongs to neither of you, the cherry is mine, and somebody has to keep order around here. "No appeal?" Caldwell inquired. "In my garden, rulings are final," said Abby. They dug until evening. Caldwell planted the first maple himself, standing with a shovel methodically, and everyone on the lot tried very hard not to watch him too ceremoniously because he hated that, and everyone watched anyway. The turtle-named judge inspected the planting holes and was twice rescued from under someone's boots. At dusk, while the adults drank tea on the veranda, Caldwell found Abby by the cherry tree. She was tamping down the soil around the sapling with the gravity she brought to everything. Miss Reed, I want to close one case. It has been pending against me since last September. He leaned on the cane. That day, you offered the court a bargain, your father's freedom in exchange for my legs. I am obliged to state for the record that the bargain has been performed by you in full, though no court on earth would have held it valid. The question that has been troubling me for a year, you could not have known it would work. 45%, Miss Reed. You stood before a full courtroom and promised something that was less than half. Why? Abby tamped the soil down, brushed off her palms, and looked up at him. The same way she had a year ago from under the 4-meter seal of the state. Because all of you do it backward, she said. All of you start with the percentages, and the promise comes after. If the percentages are small, you don't promise. With me, the promise comes first. That's how Dad operated on the turtle. First, he promised me she would walk, and then he figured out how. He says that's wrong and you're not supposed to. She shrugged. But she walks, and you walk. Maybe grown-ups just have the order mixed up. Judge Robert Caldwell, granite, a man of exact phrasing, looked at the 10-year-old jurist in soil-stained jeans and was silent for so long that they were called to supper from the house. Enter it in the record, he said at last. The court erred in its word order. The promise first, the percentages after. He held out his hand and Abby shook it, smearing it with soil, and both deemed the transaction duly executed. Let's go eat, colleague. Your cherry tree will keep until spring. We all have time now. They walked toward the house, a judge leaning on a cane and a girl carrying a turtle, through a garden that did not yet exist but had already been planted. Laughter came from the veranda. The air smelled of turned earth, of tea, and of future apples. The promise first, the percentages after. The order of words on which everything else stands.